Ready, start. Mr. Jaspal Singh, learned senior counsel appearing on behalf of the accused appellant, submitted that the order of conviction recorded by the trial court and confirmed by the High Court is not sustainable. Stop. His main submission was to the effect that there was delay in filing the FIR on the part of the prosecution witness. Stop. Had the story narrated by PW4 been correct, he would have immediately rushed to the police station to file the FIR, but he waited for around 20 days for filing the FIR, and the said delay has not been sufficiently explained by PW4. Stop. The learned counsel also submitted that the pistol had been recovered from a public place which was about half a kilometer away from a bridge, and the pistol belonged to PW9 and not to accused. Stop. There was sufficient evidence to show that the owner of the pistol was PW9 as established from the record, and therefore the recovery of the pistol could not have been a ground for conviction of the accused. Stop. Para. He further submitted that the parents of the deceased had not been examined by the prosecution, though, as per the version of PW4, he had talked to the parents of the accused after the offense had been committed. Stop. According to him, the FIR filed by PW4 contained a story which was not correct. Stop. There was no reason for PW4 to be afraid of anyone, and yet he did not lodge the FIR for a long period of about 20 days. Stop. By not examining the parents of the deceased, there was suppression of material witnesses by the prosecution. Stop. He further submitted that the statement made by the accused leading to the recovery of the pistol had not been produced in the evidence, and only the memo, which is in the nature of the secondary evidence, was produced, and therefore recovery of pistol could not have been believed by the trial court. Stop. According to him, even the memo which revealed that in presence of witnesses the pistol was recovered was not correct, because there was only one witness when the pistol was recovered. Stop. According to him, at the time of making a recovery memo, there were policemen who were not examined, and there was no justifiable reason for not examining those policemen. Stop. Para. On the other hand, the learned public prosecutor appearing for the state submitted that there was proper investigation, and upon appreciation of evidence adduced before the trial court rightly convicted the accused. Stop. According to the learned counsel appearing for the state, the discrepancy, if any, with regard to identification of the pistol or the memo of recovery were so insignificant that it would not lead to any serious consequences. Stop. According to him, the prosecution had established the case against the accused, and there was no reason to set aside the order of conviction. Stop. He had replied to all the submissions made by the learned counsel appearing for the accused. Stop.